Hi, everyone. My name is Tess Neal, and I'm an assistant professor of psychology at Arizona State University. I'm here right now to talk with you about our recent work on whether courts are effectively gatekeeping psychological assessment evidence. This work was published a few months ago in a high-impact journal published by the Association for Psychological Science. The journal is called Psychological Science in the Public Interest, and it's a high-impact journal. The paper itself is open access and it's free to the public at the publisher's dedicated website. And the paper is called Psychological Assessments in Legal Contexts, Are Courts Keeping Junk Science Out of the Courtroom? The publisher coordinated with the American Association for the Advancement of Science, or AAAS, to publish the paper at the same time that the AAAS held a press briefing about the paper at the conference in early 2020, right before the pandemic. Well, actually, it was in the early stages of the pandemic, but we were still traveling at the time. So at the briefing, stories about this project appeared in more than after the briefing, stories about this appeared in more than 500 outlets, including the New York Times, the Washington Post, the ABC News, and many more newspapers, television stations, and radio stations, both in the US and around the world. A popular blogger covered the work. It also received coverage in major international newspapers like the Toronto Star, the popular British News magazine, New Scientist, the primary Swedish newspaper. Actually, she was writing and then coronavirus happened majorly. And for the Swedish newspaper, she said this was going to have to be on pause until after the pandemic, and then she'd come back and finish that piece. Oh, that was the German. And then this is the Swedish one. A piece in the Atlantic was being written, also paused or canceled by the coronavirus. Wired magazine published a piece on it. It was recorded for The Economist. They have a podcast, and it's supposed to be on there, although they keep pushing that back also because they're covering a lot of coronavirus stuff and election stuff in the US now. But eventually it will come out. It was on NPR in a few different ways, Arizona PBS, and so forth. So now that I've told you the attention that it received, I want to tell you about the project itself. So for those of you that don't know that much about forensic clinical psychology, but probably most of you in this audience do, there's something relevant that all of these people have in common. Brendan Dassey of Netflix's Making a Murderer, Andrea Yates, a mother of 5 who confessed to drowning all of her children in their bathtub, Mike Tyson, a professional boxer who held the World Heavyweight Championship, Jeffrey Dahmer, an American serial killer and sex offender who killed and dismembered 17 men and boys, Hollywood celebrities Brad Pitt, Angelina Jolie, and their 6 children, Courtney Love, lead vocalist of the 1990s alternative rock band Hole, James Holmes, shooter responsible for killing 12 people and injuring 70 others at a movie theater in Colorado, Justin Bieber, a Canadian singer-songwriter, and Daryl Atkins, an intellectually disabled Virginia man convicted of capital murder. All of them became involved in a legal issue with the psychological question at its core. Each of these people were involved in different kinds of legal cases, but all of them rested at least in part on a psychological question or feature for which the legal system often turns to mental health professionals for help. Of the people I just showed you, the psycholegal questions for which the law asked psychologists for help included eligibility for capital punishment, civil tort for emotional injury, competence to stand trial, termination of parental rights, child custody, insanity, violence risk assessment, / fitness to professionally box, that was Mike Tyson, and competency to confess and waive Miranda rights. Mental health professionals who do this kind of work often use psychological tests as part of their evaluations. Each year, hundreds of thousands of psychological assessments are used in courts to aid judges in making legal decisions that profoundly affect people's lives. In the US, 7% of all licensed psychologists have a primary or secondary specialty in forensic psychology. And we also know that 8% of board-certified psychologists are certified in forensic psychology in the US. Over the same time period that forensic psychology has been growing and developing, there's also been a major increase in the creation and marketing of psychological assessment tools to psychologists. Psychological testing is a big business industry. There are thousands of psychological tests, and they're often expensive to use. People might assume that psychological tests published, marketed, and sold by reputable companies are based on strong psychometrics, but we put that assumption to the test. In the US, we had a Supreme Court decision called Daubert v. Merrill Dow Pharmaceuticals in 1993, and also the Federal Rules of Evidence later kind of codified some of the Daubert decisions. And these laws require that judges gatekeep or screen out junk science, and they suggest that judges can look to factors like these, among others, to make this determination about whether evidence is legally admissible in court. So we based our project on these factors. So specifically regarding the method used by the expert, has it been tested? Is it generally accepted by other experts in the same field? Has it been peer reviewed by experts in the same field? And what is its error rate? Our project sought to address two purposes. So first, we wanted to answer, on average, how scientifically valid are the tools that are used by psychologists as evidence in court? And second, we wanted to know whether courts were calibrated to the scientific validity of these tools. So as part of this project, we completed two separate but complementary studies. So part one addressed the first question and part two addressed the second. So with regard to part one, the entire project was jump-started by a paper that Tom Grisso and I did to answer this question: what tools are used in forensic settings, back when I was a postdoc at UMass in 2012, 2013. The paper came out in 2014. And so we ended up learning a lot from this process that kind of jump-started the current paper. So in that earlier paper, the one with Tom Grisso a few years ago, we surveyed an international and interdisciplinary sample of clinicians. It was 434 clinicians overall, and we asked them to report on their two most recent forensic evaluations. So it was a total of 868 forensic reports. And we asked them, do you use a tool or not? And we found out most do use at least one tool, about 75%. And then we asked them other questions, but for the purposes of this project, we were overwhelmed by the sheer number and variety of tools reportedly used by these forensic mental health examiners. We left an open-ended question. So we said, for report one, what were the tools that you used? For report two, what were the tools that you used? And there was so much data there that we hardly even focused on that test level data in the initial report in the 2014 paper. And we focused instead on kind of broad descriptive trends and the most commonly used tools. But we did have, so across all referrals, so we categorized by different types of referrals, but across all of those, the total number of different tools used was 286. That was a lot of tools, different tools, in 864 evaluations. We were overwhelmed with that data. Neither of us had heard of most of the tools. And we did some digging about them kind of preliminarily at the time. And we were really kind of surprised and dismayed at what we found. So that Neal and Grisso paper yielded 286 distinct tools that were used. In the current paper, we rely on 364 distinct tools that we know have been used or are seen as acceptable for use in court settings by psychologists. So to get from 286 up to 364, which is a broader kind of sample of what we think is probably being used in court, we relied on this work by Chris King. So he and his colleagues kind of did a big review of the literature, and they pulled together all the surveys and studies like ours that had asked clinicians about what tools were used or acceptable for use in court. So they identified 78 additional unique tools beyond which we found in our 2014 paper. So for the current project, we use this broader set of 364 tools as the basis for our investigation. The set of tools includes diverse types of tests, such as aptitude tests like general cognitive and ability tests, achievement tests like tests of specific knowledge or skills, and personality, psychological, and diagnostic tests. It includes measures designed for both adults and youth, and it includes tools that can be used to address a wide range of referral questions, including, for instance, competence to stand trial and all the other stuff that we talked about early on. Importantly, the mental health experts who responded to these 23 surveys were well qualified. So nearly all of them were doctoral level psychologists with many years of experience in the field, and a substantial percentage of whom were board certified. Manuals designed by most tool developers typically provide normative data and statistical information demonstrating psychometric properties of tools as they were originally developed. And the that gives you some information to diagnose the quality of a psychological tool. But there's other information also. So the literature, articles in the peer-reviewed literature are the most up-to-date information available. But other sources also can aid in critically evaluating tools, including well-regarded standards for what makes a good psychological assessment tool, as well as comprehensive review sources that compile available psychometric information about a particular tool from manuals, peer-reviewed articles, and other sources like websites and unpublished studies. And they provide professional reviews as well sometimes and evaluations of those tools. So these are some examples of comprehensive review sources. So the kind of bottom example here that kind of compile all the other stuff. So the Mental Measurements Yearbook is arguably the most important or most well-known, and that's definitely something we used as a foundation for this project. So in addition to the Mental Measurements Yearbook, which we'll talk more about, 2 other comprehensive review sources were used in this project. We used the Strauss, Sherman, and Spreen Compendium of Neuropsychological Tests and Grissow's Evaluating Competencies Compendium. Strauss and Colleagues Compendium provides information like background norms, reliability, validity, utility, and critical reviews of major neuropsychological tools to aid practitioners and scholars' evaluation of the psychometric properties of various tools in clinical contexts. And Grissow's text provides an evaluation of 37 specialized forensic assessment tools designed for various legal competencies. With regard to general acceptance, so we use the comprehensive reviews for one of the questions, which I'll talk about in a second. With regard to general acceptance, for another one of the legal questions, we searched 9 surveys of mental health professionals with relevance to general acceptance published in the last 15 years. Across all these surveys, 2,384 mental health experts responded, and almost all of them were doctoral level psychologists with lots of experience. In terms of coding, we developed a coding scheme by all of the project authors. And then we developed and implemented a training scheme. We had 30 coders who met on 3 full-day codeathons, we called them, to generate the results for part 1 of this project. And these coders were postdoctoral scholar in psychology and law, 2 Ph.D. students in psychology and law, 22 masters of psychology students, and 5 advanced undergraduate students who were active in my research lab. And we did 3 levels of coding. So each variable was coded independently by 4 different coders, and then 2 of those coders were assigned to work together as a duo to resolve the discrepancies, and then the duos were, at the 3rd level, assigned to work together to resolve any further discrepancies. These were some images of the codeathons. They were a lot of fun and a lot of work. Our results. Okay, so remember that the legal criteria for separating good from junk science includes looking at whether the method used by the expert has been subjected to testing. So as figure 1 shows, consistent with their roots in scientific psychology, most of the tools, 90% in our study here, had been subjected to testing. Figure 2 shows that we found insufficient evidence to make a judgment about general acceptance for about half of the tools. The 3 bars to the right show the tools for which we were able to find evidence of general acceptance. And the numbers here in the figure show you the rates of general acceptance when all the other tools are retained in the denominator. So we see about 33% were generally accepted, but 8% were unclear or conflicting evidence, and 8% were generally not accepted, and yet were being used anyway. And then to address the last 2 legal criteria, we kind of combine these into one. We coded these from the peer review sources of overall scientific quality. We used the Mental Measurements Yearbook and the Neuropsychological Compendium and Grissow's Compendium for this. And we coded the overall summary data for the psychometric strength. So results here, and these were the categories into which we coded them with those layers of coding. So we found no reviews for 37% of the tools, and then for the rest, the 3 bars to the right show the tools for which there were professional reviews available. And the numbers here show you the rates of favorable, mixed, and generally unfavorable reviews when all of the tools were in the denominator. So here we see that only about 25% of the tools had generally favorable technical and psychometric properties. 23% of them had mixed reviews, and 15% were generally unfavorable. So this is not looking great. Okay. Part 2, the major finding from part 1 was that there's a lot of variability in the scientific strength of psychological tests, and we were surprised to find many are scientifically unreliable. We know courts are required to screen out junk science, but are they? So this second question is really kind of asking what courts are doing. So to focus our analysis in this second portion of the project, we selected as exemplars 30 of the 364 tools. So these 30 tools, we couldn't do it. It was just not possible to do it for all of them, or at least not within the context of this one project. So these 30 exemplars were chosen with 2 goals in mind. So we wanted representation of a wide range of legal issues and forensic referral questions, and a variety in terms of the general acceptance and overall summary evaluations of quality. So we tried to find examples of tools that fit each combination of the general acceptance and overall quality variables. For example, we included tools that are generally accepted and have generally favorable reviews, like the MMPI, the PAI, the PCLR, and so forth. Although there are now some questions about the PCLR, even since we've some kind of high profile questions. Anyway, the reviews are still good. And we also selected tools that were not generally accepted and which have generally unfavorable reviews, hoping that the court is screening these kinds of things out. And we also, selected other combinations of variables. These 30 exemplar tools and the categories with respect to general acceptance and favorability are reviewed in are described in table 4 here, and there's more information in the paper. Our analytical methods for this part of the project, we developed an analysis scheme, and then we enlisted law student help to search Westlaw for all judicial opinions and orders from all states and federal courts in the US from 2016 to 2018, a 3-year period. Westlaw includes appellate cases, but also trial level evidentiary rulings, all of which were included in our search. We then, from all those screened in cases that involved our 30 exemplar tools, first we screened out anything that didn't involve the tools. So for instance, like if there were cases where a plaintiff's name was Rorschach or something, and we were looking for the tool Rorschach, the students kind of screened those out if they weren't actually about the tool, but involved the name of the test or something. So we had 876 cases that were screened in. And then those tests were closely skimmed by the law professors on the authorship team to determine whether the tool's admissibility had been challenged. Nope. Sorry. So we had, at step 3, we had 876 cases that were screened in, and then we decided to make that a smaller, before we read them, we decided to make that a smaller sample. So we randomly subsampled 30 cases for the 3 tools that had more than 30 cases. So remember we had 30 different tools, and most of them had less than 30 cases that involved them. Most had, 1 to 8 cases or something, legal cases that involved the tool. But some had, like the MMPI had 485 cases. So we didn't need to read all 485 to get the gist of what we're trying to do for this project. So we decided to randomly subsample 30 of those cases from the 485 that returned for the MMPI. And we did that for the other 2 tools that had more than 30 cases. Okay, so that ended up with 372 cases that our law professors closely read to determine whether the tool's admissibility had been challenged, and if so, on what grounds and with what result. This was us, our authorship team met here in Phoenix back in January of 2019 to hammer out the coding method and how we were going to do this and so forth. And this is one picture. This is Chris Slebogan, who's looking thrilled. Okay, results from part 2. In all, out of the 372 cases in which more than a mere mention of one of the 30 exemplar tools occurred, only 19 involved a challenge to the tool's admissibility or the admissibility of testimony relying on the tool. That was about 5.1%. So this data tells us that even though courts are required to screen out junk science, nearly all psychological assessment evidence is admitted into court without even being screened. On those few occasions when challenges did take place, they often failed. Only 32% succeeded. Most challenges were multifaceted, but usually the challenger's claim focused on either fit, validity, or both of them together. So the good news overall from this is that there are many psychometrically strong tests used in forensic practice, but the concerning finding is that it also appears clinicians are using some psychometrically problematic tests in forensic practice. We find few legal challenges to the admission of this type of evidence, and courts don't appear to be very well calibrated to the strength of this evidence. So what can we do to fix these problems? We see this as a systemic problem that requires a different approach by many parties, and we think these these things have the potential to make the legal cases in which psychologists are involved more fair and just. In our open access paper, which again is free at the publisher's dedicated website, if any of you want it and can't get access to it, email me and I'm happy to send it to you or share the link with you. We offer concrete advice for members of the public interacting with psychologists in the legal system, for lawyers and judges, in terms of how to challenge these tools and how to find information to effectively challenge them, and to prepare your experts to survive a challenge, and also for psychologists, both for psychological scientists who want to advance the data on these tools and or create better tools, and also for practitioners. So just a shout out to everybody. There were a lot of people who were involved in this project, and I am very grateful to everyone for their help. Thanks so much.